Oh, there it is.
Yep, but I'm waiting for it to come up on my screen so I can mute it. So if you give me one moment, it says we're streaming before it actually shows on my screen that we are, and I'll have an echo if I don't
Got it.
wait for it to pull up. Okay, let me mute this. Okay, I'm good, Madam Chair.
Okay, fantastic. So I'm going to call us to order at 8:39 p.m. East Coast time. Madam Secretary, would you mind dropping the link to the OneNote in the chat?
Sure,
Just
just
to make
one
sure
second.
everybody.
Well,
can
I'm
have
also,
that.
I'm going to share my screen, and it is up, it's on the screen
Great.
up at the top, but let me just find where my Zoom controls went off to. Okay, on the screen up at the very top, it says link for OneNote, but it's a tiny URL and it's AUG EC 2022 meeting. I'll stick it in chat as well for people, but they can always find it there.
Okay, great. So I'd like to do public comment and roll call. I think we've got everyone here, so I think that it's fine for us to go ahead and do roll call now, and then we can get into public comment. And in the meantime, if everyone would go down to the bottom where you see it says participants, that's what I'm going to be looking at when we call on you. So then right next to that, there's reactions. Raise hand. If you want to speak during public comment, please raise your hand. We're gonna, let's see, if there's not a lot of hands, we're gonna make it 2 minutes each. If there's a ton of hands, we might have to trim it down to 1 minute. But okay, so Madam Secretary, whenever you're ready, we can do roll call.
Okay, and I do like to just note the LNC members that are here, even though they're not on the EC. So I'm just going to go down the entire LNC list. So Madam Chair is here, Mr. Smith. Okay, Mr. Smith is absent. Mr. Hagopian is present. I am here. Mr. Bowen, I know, is here. Mr. Elliott is here. Mr. Nikela. So Mr. Blankenship.
I am here.
Mr. Rufo. Okay, Mr. Rufo is absent. Mr. Benner. Mr. Duque.
Here.
Mr. Eklund. Okay, I don't see Mr. Eklund. Ms. Eiler. Don't see Ms. Eiler. Mr. Ford. Ms. Gabbard.
Here.
I saw Mr. Nana and I saw Mr. Watkins. Mr. Clark. I don't believe Mr. Clark is here. Mr. Cowan.
Present.
Mr. Dassing.
Carrie's here also.
Okay, let me note that. Mr. Dassing. Or Dassling. Mr. Hall. Okay, I don't see either of them. Mr. Nepomuceno.
Present.
Mr. Pankey.
Here.
Mr. Tunjevich. Okay, I do not see him, and I see Ms. Yanuskavich. So the bold names on the screen, Madam Chair, are not here, but the only executive committee member missing is Mr. Smith.
All right. Okay, so let's jump over to public comment. Thank you very much, Madam Secretary. The only hand I see up right now is Pietro. Pietro, do you say your last name Garacci or Garassi?
Geraci.
Geraci, okay.
Yes.
Please go right ahead.
Absolutely. Thank you, Madam Chair. Hi, everyone. My name is Pietro Geraci. I currently serve on the Executive Committee of the Libertarian Party of New York, as well as chair the Orange County, New York Libertarian Party. And unfortunately, a lot of this is aimed at the previous LNC, but I'm rather peeved at what they did to the LP of Y, because we basically went and begged them for funds to help pay petitioners to get Larry Sharpe on the ballot. And they promised us the funds. And then they're like, oh, no, sorry, we're going to attach these strings. And that proved highly problematic. And I think that played a role. There were other factors that definitely played a role in the current struggle that we're in. I think the only way to rectify it, even though it's not the current LNC's fault, I still think they have a responsibility to rectify this in any way that they can. And I think a good way to do that would be to just give any funding possible to future challenges, our appeals to Part ZZZ, which is what got us into this mess in the first place of the New York State budget in 2020, and perhaps getting our challenge all the way up to the US Supreme Court. I think that would be the best course of action in any way that, you know, think otherwise, but there should be some sort of rectification there, because I do believe that the LPNY was gravely wronged by the shenanigans of the previous LNC and its committees. Thank you.
Thank you very much. I believe we have Justin Carmen up next. Justin, go right ahead.
Hi, everyone. I am Justin Carmen. I am the vice chair of the Albany County Libertarian Party here in New York. Pietro took a lot of wind out of my sails in what I was going to say. Essentially, the funds came to New York, and I realize this is not on anybody's, fault here, but, in the prior term, the funds came to New York a late and short manner that kind of really killed us. We were only a couple of thousand signatures short. And, I think we're still kind of tabulating what the total costs of this signature collection effort was, but it was north of $250,000. That is a enormous expense. And to fall that, short, it's a tough bullet to bite, knowing that had we had the money, in the promised amount and, on time, like we had expected, we're probably not facing this situation. But that being said, we are where we are today, and we are facing a really grave and difficult threat legally here in New York regarding getting back on the ballot. I would advocate and I would implore the board to go ahead and consider approving these funds to go ahead and move forward with this appeal. Partly because I think when you go ahead and hear about Gary Denoyan's thoughts about the case, this has a potential national aspect outside of New York, and that would do a lot of potential good to the party, even if the case isn't well received here in New York. I would like to see, a greater effort done here to more than just us, if we can at the same time. It's one of those things where it honestly will probably pay us in the long term to invest a little money now to not invest a lot of money later. Thank you.
Thank you, Justin. Okay, so next up we have Ms. Harlos.
Madam Chair, please put me at the end. Mine's more in the nature of an announcement when everyone's done talking.
Got it. Okay, up next we have Mr. Jacobs. You have 2 minutes.
Hey, I just wanted to comment on what the two guys from New York said. I basically agree with them. The only thing I wanted to add was the one guy said they came about 2,000 signatures short. That was 2,000 signatures of the 45,000 minimum to turn in. That doesn't mean you had 45,000 valid signatures and would have survived the challenge. So I don't know what the validity rate was on those signatures, but chances are to come in with a challenge proof number at 45,000, you probably would have needed to turn in at least 70 or 75,000, maybe more if the validity was bad. So, and the cost would have been a lot more than $250,000. It would have been way more. I can tell you, going way back to 2004, the Libertarian Party did a drive in Texas. And at the time, it was 45,540 valid signatures needed, and they had 90 days to do it. And back then, it cost the party over $200,000. Okay. There's been a lot of inflation since 2004. So if you look at that, I think it would have cost a lot more than that to successfully complete New York this year. But otherwise, I agree with what they said. And I think it's really unfortunate that Mr. Sharp didn't make the ballot, because not only is he a really good candidate, I think that he would have stood a really good chance of getting the 3% of the vote. And then the LP wouldn't have to petition for president for 2024. But anyway, I guess if there's a few more seconds, I'll throw in. New York has a thing where you can only sign for one candidate for each office. And so that eliminates the ability to piggyback off of other petitions. You know, if somebody else is running, you have like the Green Party or whoever else is running, you can't really piggyback if a New York voter can only sign one of them. And so that was thrown out. Pennsylvania used to have the same thing, and it was thrown out in Pennsylvania. So I don't know if it'd be possible to get that thrown out in New York, but that would be one thing that could possibly help. Another thing is that New York has pay by the hour instead of pay by signature.
Andy, you're at a little over 2 minutes now.
Oh, okay. Well, that's what I was going to say. Try to get that thrown out.
Okay, thank you. Anything else you guys have got? If you go over 2 minutes, drop it in the chat for us. Okay, next up we have TJ Kozin. Is that how I say your last name?
Yeah. So I am from LP Bucks. I'm also on the National Candidate Support Committee. We have 2 candidates out of Bucks that have very significant implications within Pennsylvania. I know our chair will go over more in detail later, and we can go in more detail. We have a congressional candidate running against Brian Fitzpatrick. Anyone who pays attention to national news knows Brian does not align with anything that we stand for as a party and consistently votes against basic common sense constitutional aspects of legislation. Caroline, I believe, has already spent $3,000. She's probably going to need an additional $5,000 to fight at the Supreme Court level. Brittany's probably, we just got wind that she's going to need a total of $5,000. We are contributing $2,000 out of our own campaign. I believe Caroline is as well. But we're going to have to fight at the PA Supreme Court under sore loser. They're going after us because we initially ran as Republicans, both candidates. We were disenfranchised with the party, with the corruption that was there. Left, came full head into Libertarian Party. Obviously, I'm Brittany's husband. I've joined several committees. Caroline got 4,800 signatures, which was a workhorse in Pennsylvania. Brittany went to several events to help candidates get on the ballot. Also in Pennsylvania, we've had the most candidates get on the ballot since 1994. So we need help from national to help fight this case in the Supreme Court.
Okay, thank you very much. And Andy, please mute your mic. Okay, next up we have Pat Ford.
Madam Chair, just briefly, a little bit of history in the last term of the LNC when this subterfuge happened to the New York committee. Mr. Bowen and I worked aggressively for a couple of months running up to the LNC budget meeting to make sure that there was funding available for the New York party. And that's when afterwards we found out, much to our delight, that this sort of bait and switch, in my words, had occurred. Fortunately, as in the case of New Hampshire shows, in other cases, that is behind us. I would urge folks to support this motion because I believe it's a critical, important step to at least finalize and take to a logical extreme what we can do and what lessons we can take elsewhere. I just, for the record, have to point out, though, that it is clear that we have to work on the DNA of the Libertarian Party. We are no longer in a position to be able to write checks for ballot access. I urge everyone to look to themselves, myself included, to find more ways that they can volunteer for ballot access and aggressively expand volunteerism in our own party for our own benefit. That has to happen now. We need to learn from this lesson. Thank you.
All right, thank you, Mr. Ford. Up next, we have Mr. Bill Redpath.
Yes, I want to, first of all, second exactly what Pat Ford said regarding getting more volunteer signatures going forward. Here in Illinois, we paid between $5 and $7 per signature during the petition drive. I myself went out over a 3-month period and did 7,181 volunteer signatures. I put over $40,000 of my own money into the Libertarian Party of Illinois petition drive. But my point is the volunteer signatures. We definitely need more volunteer signatures going forward. With respect to the criticisms that were brought forth by the two gentlemen from New York. I am the person who said that recommended to the executive committee that they're put benchmarks and goals in, and I do not think the Libertarian Party of New York asked for $30,000 from the LNC, and it ultimately got $30,000. So I'm very sorry about this situation in New York. I want everybody to get on the ballot. I've worked hard since 1988 on ballot access, since 1990 at the national level. It is horrible what has happened to minor parties in New York, including the LPNY. But I brought up the fact that this was the toughest petition drive ever in the history of the Libertarian Party, that it was questionably feasible from the get-go. And it was not, this petition drive in New York was not done in a transparent manner. The Ballot Access Committee, the National Ballot Access Committee, for many weeks could not get any numbers out of the Libertarian Party of New York regarding how many signatures were gathered. And it is a horrible petitioning requirement, but if you got 43,000 gross signatures when you needed 45,000 net, you did not come close to successfully completing this petition drive, as unfair and obscene as the petition requirements are. So from my perspective, I do not regret recommending to the executive committee that benchmarks be put in place. And by the way, the money was given, even though the Libertarian Party of New York was not hitting the petitioning benchmarks, the money was given anyway by either the executive committee or the LNC. So ultimately, those benchmarks were waived, and the full amount of the money, it is my understanding, the full amount of the money that was requested by the LPNY eventually went to the LPNY.
We are at 2 minutes, Mr. Redpath. Thank you very much. And we're going to call on you to speak later, because I would definitely like more of your opinion. Okay, up next we have Mr. Rob Coburn.
Thank you, Madam Chair. I'm Rob Coburn, Chair of the Libertarian Party of Pennsylvania, and I'm here to speak for Ms. Avery and Ms. Cozen, our candidates being challenged. We have an opportunity here in Pennsylvania to overturn the unconstitutional sore loser law, which both of our candidates are being challenged under. The attorney that we have hired has won on these grounds before. Now, nothing is a guarantee. I'm an attorney myself here in Pennsylvania, and nothing is a guarantee, but our attorney that we have is rather confident. Miss Avery herself achieved, her campaign achieved 4,800 of our 10,000 signature goal for our statewide candidates. Had we paid her as a paid petitioner, we would have paid over $10,000. Our entire drive was all volunteer. We in Pennsylvania have already given as much money as we can to Carolyn Avery's campaign. We've given her 5,000. We can't give any more. But her case and Miss Cozen's case have the potential to overturn this unconstitutional sore loser law and make ballot access and getting on for going here in Pennsylvania going forward easier for every candidate that we've got. So I urge you to please consider helping out for the legal funds to overturn these bad laws here in Pennsylvania. Thank you.
Thank you very much, Mr. Coburn. Okay, Madam Secretary, would you like to go ahead and make your announcement?
Sure. And I apologize for taking time away from these two subjects. It's just I have the captive LNC here. Mr. Elliott had a question earlier, and I figured if he had it, everyone did. On the information I sent to the LNC before regarding the new organization procedure for party records, that was for informational purposes only. You will not have access to that drive. Only the chair, the secretary, and the executive director do. It was just more for your information. So anyone who's going to look for that shared drive, you will not see it. A video will be produced for the LNC coming up soon, showing how to upload your reports, which will be to a designated drive. And lastly, there was some confusion with new LNC members on OneNote. The OneNote link is always in the thread that announces a meeting. You don't have general access to our OneNote library because some people were looking in their drive for something that said OneNote. You need to look in the notice of meeting. I will always post that in the thread. And if you can't find that LNC thread, this goes for members as well. I post every notice of meeting also on the main webpage of lp.org. You could go there. The link to the meeting is there, and also the link to the OneNote is there. So I hope that clarifies things for the newer LNC members, you know, on how to find all this stuff. Thank you, Madam Chair.
Thank you very much. So the first item on our agenda proper is going to be LP New York. Now, what I'd like to do is I'd like to give 15 minutes, because last time we did this, 10 minutes was not quite enough. I'd like to give 15 minutes to Mr. Sharp and his attorney. I'll be keeping track of time. At that point, we're going to sort of wind down their discussion, and we're going to open it up to LNC members. And at some point, I may end up passing the gavel so that I can argue. We're going to just kind of see how things go. Mr. Sharp, if you and or your attorney would like to speak, please take it away.
I am here. Can you all hear me?
Yes.
Excellent. The issue that I want to bring up regarding the monies that came to New York State, Mr. Redpath is incorrect. We did not get the full amount. We got half. We were initially promised 30,000 and we got half of that. But the issue isn't whether or not we got half of it or not. Mr. Redpath was on the phone call when we were talking about this earlier, and I was very forward with him. I said, if you're going to put these restrictions on the money, I don't want it. That was what I said. I was very forward about it. I said, if you're going to do that, I don't want it. I will find another way to raise the money. He was a bit shocked by that, but I was very forward. Either give me the money or don't. I have to budget. I only have 6 weeks to make this work. My plan will have multiple points of failure. And if any of them fail, we're finished. So literally, I said that. Then about a week or two later, whenever it was, the committee agreed, we'll give the full 30 up front. I said, awesome. I was happy. I was on that call. Then a week before, that was changed. I wasn't even on that call. I wasn't even informed until later. How could I then go back to my donors and say, well, remember I asked you for that $40,000? What I meant was 70. How? When I remember that $20,000, when I asked for more? Well, no, I was wrong. How do I go back to my donors and do that? If you've ever raised money from heavy hitter donors, they don't like that. So the reason why I felt backstabbed is not because you guys decided you didn't want to give me the money. It's because a week before you changed the rules when I was very specific and I said, then don't give me the money. Yes, I'm upset because of that happening, that ruined everything and made everything harder for me the way it is. Is that what Pietro said? He's correct because he was there and he watched it. He saw how all of a sudden now I had to worry about what vendors I could use. Now I had to worry about what people I could use. And the worst part is when that began to fail, when NYLP couldn't pay its bills and my campaign stepped in to pay the bills, all of a sudden then we lost confidence. And when we lost confidence, that's when volunteers don't believe it's going to work anymore. When people start saying what Mr. Redpath was saying 1,000 times, this can never work, this can never work, this can never work. Well, why would volunteers try? When they've been telling that it can never work. And when LP decides, well, we were just kidding and we're not going to give you the money. This was not helpful, but I pushed on anyway. So we pushed on and the campaign decided to do whatever it could to still pay people. So yes, we came up short. We might have actually come up far, far better if all the other failures didn't happen. So I just want to be clear. And we never got the full 30. We got 15, literally the last week of the campaign. Literally. The last week of the campaign. That's when we got the 15 out of the 30. We never got the 15 ever. The other 15 ever. So that is incorrect. So with that in mind, as I tried to push through anyway, we were so strapped at the end, because this goes to other people who are talking in the chat. You only actually get 5 weeks because a week is to prepare before and after to figure out how things work. We were so strapped, literally, I had 5 minutes left when I put the signatures and when I submitted the signatures. 5 minutes left of the day. They closed the door behind me. We couldn't even count the signatures. We had 5,200 sheets. We hoped it was enough and we submitted them. Some we couldn't submit. Why? Because to the other part that we happen is there's tons of fraud, which our Republicans try to get on. Andrew Colsey and the hard work him and his team did figure this out. Literally, they had 13,000 photocopy signatures. We found that we had some photocopy signatures too, and we pulled them out because we didn't want to commit fraud. I know it sounds crazy. We had that too. We had the same problem because we had to use any vendor we could get because we were picking vendors who didn't want their money up front. So we picked every vendor we could possibly get, and some of those vendors were kind of shady, obviously. So that was another problem that we have. So the issue isn't whether or not the money was given. The issue is the way it was turned. That's the problem. And I think if I understand Pat right, that's why Pat was saying debate and switch. If you had either said, Larry, that's the only way we're giving you the money, then I would have said, great, I don't want it. I'll find another answer. Or Larry, we're giving you the money. I would have taken it and we would have run the right way. This is the specific problem that bothers me. Let me move on if I could. Next time we do this in 2022 or 2024 for the presidency, if I don't get on the ballot this year, or if I don't get 130,000 votes or 2%, whichever is higher, that's how New York State works, 130,000 votes or 2%, whichever is higher, it's going to cost the LP $500,000 to get ballot access in New York State. I'm not joking. It will cost $500,000 because the guys who also could make it was a multimillionaire by the name of Harry Wilson, who's worth $50 million. He couldn't do it. And a sitting congressman who had raised $12 million. He couldn't do it. We will only be able to do it if we're able to both raise a bunch of money and someone like me or whoever is the 2024 equivalent is going to run around the state, motivate people and make things happen. We can do that if you want to, or you can hope you have a presidential candidate who decides they want to spend 6 weeks running around New York State trying to get signatures. Either of those two could work. Or we can drop another $15,000 right now, do a lawsuit that might win. And most important piece, if it wins, will not just affect New York State, it will affect the entire country. And not just for this, but actually for the entire, for the next generation in New York State. I'm going to ask Gary Denoyan to come in and give you some details on that. But that's how important this is. We have fought before. We can fight again. Gary Denoyan is the guy to do this. Literally, he got someone on the ballot after many, many appeals before October 20th, 3 weeks before the election. You might say, Larry, how can you do anything 3 weeks before the election? I'm already known in New York State. I am polling currently at 7% in New York State. If we get 6 million people in New York State voting, do the math. 400,000 votes. If half of them actually come together, that's 200,000 votes. That still makes it right. We can still win this thing and get ballot access. Right now, I'm pushing a writing campaign. I'm raising money to get stamps so we can stamp Larry Sharp on. That's what happened recently in New York State. In New York State, our second largest city, Buffalo, the mayor won with a writing campaign. Stamps. I'm going to copy what he's doing. I'm going to try exactly the same thing. I'm not surrendering. I'm still moving forward. We can make this work. The lawsuit is incredibly important because if we win this thing, I will be the only independent candidate on the ballot. In New York State, that is 250,000 votes. That's what happens in New York State. There's 250,000 people who will vote not these two. And that is consistent in every election. I will get all of those votes plus the people who know me. So what I'm saying is this is valuable. It's important. It will get us, without question, out of paying $500,000 in 2024. And more importantly, the more popular that this race comes, the more popular that I am doing what I'm doing, the easier I can raise money for our presidential candidate, which also matters. The easier we can push forward and make things happen. Some of you see how I've been campaigning and the press I've been getting. It does matter. This is very important. Gary, can I get you to come in and talk for a few minutes about the lawsuit itself?
Yeah, sure, Larry. Great job explaining the background of it. I wanted to start by saying, you know, as an attorney and an advocate, I want to be an advocate for my client, who includes Larry, and the LPNY. And even though the LP is not my client, I feel like I want to advocate for the LP. I don't want to be in the position of advocating for this lawsuit. Okay, I see my role now as kind of explaining where we are. I do think it's a good idea, but I'm uncomfortable being in a position of trying to argue that this particular lawsuit is the be all and end all. It's a difficult case. We're relying on a couple of grounds and hoping that we get past certain other technical limits. But the judge set us up in the trial court for having some success, potential success on appeal. There's a statutory section that has to do with technicalities of procedure, which in this particular case or this season, in several cases, the State Board of Elections violated the rights of various candidates. So we have a right, I think that's pretty clear, to go back and have things done properly. There may be another problem. That's probably the best chance we have of actually getting on the ballot. If we remand on that technical ground, then we can find another issue, even despite a potential being short on the number of signatures. Without a valid objection, we would still get on the ballot. That's if there's a path, that's the best one. What Larry's also referring to is the constitutional argument, and that's been argued for decades. I actually recently Richard Winger on the free speech issue, the binding Supreme Court case from 1971, the Jeunesse case, which is very flawed and should be overturned. We do have a difficult precedent in our case because a different set of attorneys for the LPNY has already been in federal court on that issue and has lost on that issue. We can and have argued that things have changed in the years since that decision was made, and so we still can argue that Supreme Court case and the previous New York case are not binding here for those reasons. That's also a very long shot, but it's an opportunity to really lay out a lot of the problems with the Jeunesse case in particular, and in New York situations also in particular.
Well, Gary, can I step in for a second, Gary? Please explain that if we actually win that, how does that change everything?
You win the constitutional ground?
Yes.
We are on a path to go to the U.S. Supreme Court. Okay, we're 2 steps away from the U.S. Supreme Court right now. This is going to the first level appellate court in New York. The case Larry mentioned, which was late October, I actually went not only to this same court in late October, but also to the New York Court of Appeals, where we also won. So there is a legal path now to really overcome that constitutional ground, the Jeunesse, and to challenge and overturn the Jeunesse case. We are on a path. We've done the preliminaries to challenge and reverse the Jeunesse case. So it's technically legally possible. Any lawyer will know that it's a very long shot, but the fact is that the path to do that does exist.
So the thing I want to bring up also, thank you for that, Gary. I appreciate it. The timing here is critical. Why? Because of people like Yang and people like me and people who are becoming more popular with a third party route. They also want this to happen. You've seen there was a New York Times article on this. There's a Daily News article on this. People are seeing it, and that's going to move popular opinion. And judges are just people. They're going to be moved also. So will politicians. We have politicians now in New York State who are starting to get behind us. As they start getting behind us, they will change. So the timing for this is now, because of the people like Yang and his ilk and everyone's third party, and everyone says they want third party, but then when it actually happens, they go back to the old two. So the point is the timing is right now. The opportunity is huge. If we win big. And if we don't do this and go, forget it, whatever, Larry, good luck, and I don't get it, then we're going to have we're not going to have 50 state ballot access for this party for a generation. And I'm not exaggerating when I say that. I would ask you, are you telling me this party is going to take $500,000 and put it into ballot access for New York? It's not going to happen. And unless another me shows up to do it again, it's not going to happen in 2026 either. So it's not going to happen ever. It will be solidified in New York State. And here's the worst part. The other states will follow. Because if they can trash third parties and get rid of Yang and us and everybody else in New York State The other states will follow. They'll do exactly the same thing, and this will keep going. So we can stop it now, or we can let it go. Gary, did I miss anything?
Nope, unless people have questions, you know, I think that is the gist of the story.
Okay, so thank you guys. You're a minute under time, which is fantastic. So here's how I want to set this format up for Q&A. I've got some questions I want to ask. I read the case law. I've read the entire transcript, highlighted it, sent it around. I don't want time to get out of hand because we have 2 other matters on the agenda. So we're going to do questions right now for the executive committee and for the ballot access committee. Before we jump to that, and I see Dustin Nana's hands up, so he's going to go first. Before we jump to that, Mr. Hagopian, do you have any idea what our budget is for ballot access?
Yes. 1 second here. And I want to caution while we're talking about budget for specific items. This is, of course, all based off of the previous budget, which we are not living up to from a revenue perspective. So while I am fairly certain I will be voting in favor of this, I will also be acting as a responsible treasurer and putting in some of these disclaimers. There is approximately $71,057 left in the ballot access budget.
Great. Okay, that helps take care of that. Okay, so
Madam Chair, point of privilege.
yes, but
Actually, Rob
hold
Coburn,
on.
I have to, I'm giving Richard Schwartz and Allison Grammer the 2 to represent tonight. I'm going to be stepping out here.
Got it. So Richard Schwartz and Allison Grip.
Yes.
Okay. Okay, thank you so much. Thank you for hopping on. Okay, so let's jump to Mr. Nana.
Okay, thank you. So I have one specific question, and I'm sure I will have more later. But the first one that jumps to mind is why $15,000 specifically? Where did this number come from? What specifically is so crucial about 15,000? Why is that the specific ask today?
Okay.
Is that a question for me or is that for someone else?
For Larry or for Gary?
Yeah, Larry, why don't you take that one?
Yeah, it's $15,000 because of the 30, I got 15. I'd like the other 15. That's why I'd like that. The case will probably cost somewhere between 10 to 12 is the assumption, but it might cost more. So I want to have a buffer just in case it costs more. So I picked 15 because that's what I think I should get because that was promised to me before. That's the reason why. If it was in your budget before, it's in your budget now. That's why I picked 15. However, the case will cost somewhere between 10 and 12. If you want to go 12, I'm going to whine a little bit, but I'll shut up. But that's why I wanted 15.
Can I ask Larry, do you have additional campaign expenses to take care of?
I have tons of them, but I'm raising money and I'm not asking you for anything extra. I've already raised what, $300,000 or $400,000 already. So most of this was done without the national, which is, look, I'm not trying to be a jerk about that, but I do raise money. I raised $500,000 last time. I'm still raising money now. One of the reasons to have a lawsuit, believe it or not, for those of you who know, is it gives a reason for people to raise money also. It's a good story. We talk and people have hope and people want to raise money. So this also helps in me raising money. So yes, I have lots of campaign expenses. The campaign actually right now is in debt, but I'm still raising money.
Okay. Todd Hagopian, go right ahead.
I think Secretary Harless was first.
Oh, I missed it. My apologies, Ms. Harless, go right ahead.
Trying to find my, first of all, thank you, Larry. I truly loved what you had to say here. And also I read the transcript of the hearing and I thought you did fantastic in that hearing.
Thank you.
Wayne, can you shut the door, please? I'm sorry. That's going to happen every meeting, but the birds were going. I have a question and I want to know if I'm just fundamentally misunderstanding something because I only reviewed it earlier today, but I took a look at the order as well. I didn't care for the order. I don't want to disparage a judge, but I just didn't care. I didn't think it was very well written. And it seemed to me he miscast a little bit of what happened at the hearing.
100% true. Yes.
Yeah, it seemed like you guys were saying you'd be perfectly amenable to, and we're kind of waiting to see if the court was going to make a move towards having an in-camera inspection, that the
Yep.
whole issue of the 5,000 signatures, you did not concede that you were short.
I didn't count them. How would I know?
Right. And so he made it sound, so I was correct that I read his order was kind of like, y'all didn't even want them counted. I think you did.
I agree to all of those things. Absolutely. In addition, I said, if you remember, I literally said constitutional was
Yes.
unconstitutional. I said it in my
Right
speech
here.
and I put it in writing, and he said I never mentioned it. The judge literally lied in what I said. You can disparage him all day. I do. His name is David Weinstein. He's a terrible judge. You can all disparage him. He literally lied in what I said. He did not hear what I said. He mischaracterized everything and took 3 weeks to hammer me.
Okay,
Correct. You are
my
accurate.
next question was about, I saw he said Constitution didn't come up once, and I'm like,
I literally
wait.
said it and wrote it, both.
okay. And just an FYI, the reason why I'm reluctant to say anything bad is I do have a voluntary license as a paralegal. I've got to be very cautious about what I say about officers of the court. So, but thank you, Larry. I wanted to make
Yep.
sure I wasn't misunderstanding.
You're not crazy. He just decided that it didn't matter. He was just going to tell me no, even though it was completely wrong.
Okay, thank you.
Okay, next we're gonna go to Mr. Hagopian, and then I'm gonna hop in.
Yep, I have two very quick questions, one for Larry and one for Larry Familiar. I apologize, I don't know the name. Larry, if this comes down to a write-in campaign, I'm just unfamiliar with the laws in New York, and you get enough signatures, how does that work? Do you get the Libertarian Party on the ballot, or is it like Larry Sharp? Like, do you qualify next time around?
Yep. Gary will help me to make sure this is clear, but I'm pretty sure. As I said, we have a precedent of write-ins in New York State. Just recently, last year, the mayor of Buffalo, which is our second largest city in New York, actually won with a write-in. And what they used was to help out with stamps. So we'll be using stamps, handing them out, selling them, purchasing them, so that people walk around with stamps and they'll stamp. And if we actually get 130,000 write-in votes, as long as I am, the law isn't clear. Again, I'm sure Gary will be more detailed than this, but it basically says if I'm part of a party and I get the votes, I get the line. It would be the Libertarian line because I am part of the Libertarian Party and part of the Libertarian line. We went through all of the motions. I got to be happy with the Libertarian Party. We went through all of the motions to be a party and are still doing it, even though New York State doesn't recognize us. So we've done everything appropriately. So yes, we should be able to get ballot access. Gary, do you want to give some details on that?
Yeah, Larry was the first one to bring that to me as to whether a write-in candidate for governor could qualify a party with sufficient votes. I was skeptical from my initial reaction, but as I studied the rule on my free time, I'll read it quickly. The term party means any political organization which, excluding blank and void ballots at the last preceding election for governor, blah, 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 received at least 2%, blah, blah, blah. The phrase is political organization which its candidate for governor received. And I think the expectation was that it would be a person on the ballot, but it really can't be fairly denied that the political organization whose candidate for governor was Larry Sharp is the Libertarian Party of New York. And it could be that case would be lost, but I think it's a fair argument, and I think it would have a good chance of winning. You can't guarantee. It's probably not what was intended, but that's a pretty strong case. That especially because in 2022 the LPNY did go through the official procedures to nominate Larry Sharp as if it was a recognized party, which it had been up to 2020. So I would say the chances are excellent that it would qualify even as a write-in.
Okay, and then second quick question is just, we know 500,000 or so to do ballot access next time around. And I probably should know this, but how much would the Supreme Court case cost potentially?
What do you mean by the Supreme Court case?
If he's asking if we took this over to Supreme Court, how much money would that cost for lawyering, Gary. That's what he's asking for.
Filing fees, litigation, the whole thing.
Well, okay, there's a New York State Supreme Court, which we've already passed that level. That's where we just got.
Yeah, it's just
Are
different.
you,
in
are
other
you referring to
states.
US Supreme Court?
No, no, no.
Ba-
We're
No.
Basically, what I'm saying
Then-
is it's very, very unlikely that the LP would pay for both, right, Larry? Like,
Correct.
for
I'm not
2024.
asking for both.
yeah.
I'm not
And
asking for both.
saying, I just want to know like what the cost comparison is if we take it all the way through the courts rather than try and fight this again in 24.
Well, the reality of it is if this has to go to Supreme Court, I'm not asking the LP to pay. I'll find
Right.
donors and for you, it's nothing.
Okay,
Okay.
perfect.
Just to be clear, are you referring to a potential appeal to the US Supreme Court this year? Is that what you mean?
Yeah, I
Not-
read of
obviously not
certiorari.
this year.
Yeah,
Obviously
yeah,
not
no,
this year, but
that's nearly, that's very, very unlikely to happen.
yeah,
Um,
no,
but-
I knew that. We're good. I think Larry answered my question.
Yes, it's
Okay.
going to cost you nothing because I'm not going to ask you
Okay.
for the money. If I'm going to
Okay.
Supreme Court, I can find people for that.
Yes.
That is, yes, that's so popular. I can find donors for that. No worries.
Agreed. Thank you.
Okay, all right, I'm up next. I think I need to pass the gavel technically. I think Karen Ann is next up if Josh isn't on the call.
I think I'm eligible to take the gavel, Brian Elliott, am I not?
I think I got to go to the next officer or else. I lose
Joshua
Brian.
is here unless he wishes to debate,
Oh, okay.
or
I am-
if his
I am here.
family.
I am here and I don't need to debate, but I am trying to get my 2-year-old to sleep. So I could give it a go if you need me to. I'd be okay with that.
All right.
Ms. Chair McCardle, I can take care of it. I don't.
That's fine. Yeah, that works for me. Whatever works. Okay, so I got some things to say. Yeah, I also work as a paralegal in litigation. I have no issues disparaging a judge. I thought the order was really rotten. While I'm hurting people's feelings, let's just go ahead and let's talk a little bit about the previous case. I appreciate very much that people stepped up to try to help LPNY in the previous litigation. It's been over 6 months since I looked at it, but I don't think that there was a very good legal argument made. And that sucks. It is what it is. It happens all the time. It's nothing personal, but I would not have touched that legal argument with a 10-foot pole. And it created some additional challenges for Larry and the LPNY right now, because one of the things that they're facing is collateral estoppel, which is very similar to res judicata. And they're basically saying, you can't make the same argument in court twice. Those of you who've seen that movie, Double Jeopardy, it's like that. But they do have an opportunity to defeat that because they have basically new evidence. You can think of it as new circumstances. That's one of the ways that you can overcome that. And some of the comments that Larry made in the hearing, the transcript, when he talked about how no one else was able to meet this burden, that's very new information. And they hadn't tried it at that point. And the fact that these other two really wealthy, well-known guys could make it is also really, really powerful. I think that the case law that Gary was citing, I think he's correct that it needs to be overturned. I also think that a lot of every single case that opposing counsel, the government's attorneys cited, was cited improperly. They compared Larry's case to a case where someone had to collect 750 signatures within 6 weeks and said it was the same. It's nowhere near the same. 45,000, 750, very different numbers. It's not a slam dunk, but I think that it is a much more financially responsible thing for us to do, to try to spend $15,000 or $12,000, whatever you guys are comfortable with. I think it's much more financially responsible for us to try to do this than it is to say, oh, you already dumped over $300,000 of this, into this campaign. Sucks to be you. We'll just blow this off and try to make it again in 2024 for 500K. The reality is, whether we like it or not, the New York LP is kind of burned out on this. And I don't feel confident that their leadership is going to work really hard on this in 2024. And I'm not saying that as a dig at them at all. I understand. I'm saying that because they're looking at the reality of the situation because they've lived it and we're sort of on the outside. So to that extent, I think that it's a good decision for us to make financially. I think it's a good decision for us to make for an affiliate that basically signals to the rest of the country, just like California, how ballot access laws could go. I think it's a good gesture for us to do for someone who is probably the biggest fundraiser in the party. We all know that. He's raised a lot of money for us, for the national party, obviously for candidates and state affiliates. I think it just makes sense. I don't want to get into the details of what happened on the ballot access committee the last term. You guys have heard it from Larry. You guys have heard it from the ballot access committee. But I think that we can sort of gently sidestep all of that and just try to make things right going forward. That's all I got to say about that. So whoever's next in queue, Karen Ann.
Yes, Mr. Hagopian, I don't know if that's an artifact or you had your, okay, thank you. Mr. Nana?
Thanks. I had a few things to say, but I think this is the most important when it comes to the discussion at hand. There is a candidate that did this while not on the gubernatorial line. As far as I understand, there is an independent Senate candidate who did this year. So I don't know if this whole argument rests upon whether or not this is possible is going to hold up when somebody just did it. I might be mistaken, but I am 99% sure there is an independent Senate candidate who did pass the signature requirements this year.
Yes, this is true. This is a woman by the name of Diane Sayre. I actually know her. She's not a bad person at all.
Full disclosure, that person was also my client, not in any post.
Yeah, we were together in one of the literally sitting together in court.
That's right. That's right.
Yeah,
We were in court
100%.
the same day.
The issue is, there are two issues. We don't know if she actually did it or not. I am not accusing her of anything, but no one challenged her. Why? Hers is not a ballot access run. If she wins, if she becomes senator, her party doesn't gain ballot access. So no one challenged her. No one checked her out. No one even tried to stop her. No one did anything. So it is possible that she made it. It's also possible she has 30,000 photocopies. I don't know. So that point, which is what I brought up in court, is we don't know. So how can we put that into the same bucket as the other bucket when we don't know if she has valid signatures or not? She got it because they didn't check. If they had checked, it would be a valid comparison. They didn't. So it's not a valid comparison.
Second point, the second point is it may be they didn't check because she wasn't a governor candidate.
Correct. They actually said that if you saw during the transcript, I said, you never checked. And they went, you're right. So they never checked. So they took her face value and didn't take mine face value, even though they didn't check hers. They admitted right there in court. No, we didn't check it. So they have no idea if it's good or not. Again, I'm not saying that she didn't do it. She might have done it. My point is they never checked and nobody cared because she's not a ballot access.
It dawns on me there's an equal protection argument because they can't explain why they checked Larry's petition, explicitly admitting that it's not because of any objector he had.
Correct.
And at the same time did not check Diane Sayre's petition.
They admitted in court that they checked mine, but didn't check hers.
Right.
Hey, thank you, Mr. Nikala.
Larry, it's good to see you and hear from you. Hopefully you can spread some liberty across the Hudson River as well to Jersey.
Doing my best.
I just want to get an idea of, all right, we give you the 15,000. What's the timeline look like? Are we, what do we expect to hear back from the court? How do things go from there? What are we expecting? What's our milestones?
Well, I'll have Gary talk about the details, but here's what I'm doing already. I am just campaigning. That's what I'm doing. I am campaigning, and right now I'm campaigning as if it's a write-in campaign. I'm assuming that we're going to lose, and I'm campaigning as a write-in. That's what I'm doing right now. I'm the only other candidate that's running, and the funny part is the media is actually still accepting me as a candidate because they know me from last time, even though I'm not in the ballot. You probably saw just today I was on Kennedy about 2 hours ago. So literally I'm still doing the things as a candidate no matter what. If we lose this thing, I'm pushing the write-in. If we win the thing, then we still get on the ballot and the write-in is even better. People just check my name. But time-wise, I know Gary's going to start the process immediately. Gary, can you give some details on timeline, what you think how long this might take?
If we if we decide to go ahead with the appeal, normally at this level of appeal, the appellate divisions in New York, there'll be a calendar set up every year on a case by case or a year by year basis, what the filing deadlines will be. But that's much more common for the primary elections, which are what typically only, matter to the powers that be so much, and also more for the New York City type basis. So this particular court, we're now go to the default rules, which gives us 30 days from a filing of note of entry to appeal. We have plenty of time, but of course, now we're just faced with a political problem with a delay. Legally, it's perfectly fine to even put it off another couple of weeks. I just hate the idea of having put it off. So Larry's right. The moment we decide to go ahead, I would instantly get the notice of entry filed, the notice of appeal filed, and arrange a briefing schedule right away with the appellate division.
Do you think this can be done in a couple of weeks, Gary? Do you think this is possible in a couple of weeks?
I would expect to get a briefing schedule for briefs within a week and a half, and oral argument within a week after that. So 2.5 weeks from the date we decide to go ahead.
And the glory of this is if I get on the ballot fast enough, I will be in the debates. I didn't even bring that piece up. If I get on the ballot before October, I'll be in the debates. Imagine me in the debates with 2 other people in New York.
That's right. We're still in August.
That's correct. The debates go in October.
Right.
So if I get in on time, I'm in the debates. How do I know that? The League of Women Voters has already told me this. So I know this will happen. Imagine if I get in debates. If we have an actual chance, if I get in debates, of doing a Jesse Ventura and me winning this thing in the 90s, what he did. So we have an actual chance. It could actually happen. I could win this thing. But even if I don't, I come in second. Oh my God. Oh my God. It's insane. So this is what could happen.
And I see Mr. Nana has his hand raised again, but prior, Chair McCardle had said, when the executive committee was done asking questions, if some other LNC members have some questions, now's your chance to get in line. Mr. Nana?
All right, this is probably the last question I ask because I want to let us move forward. But I guess my question is, do you not have money to be doing this case already? Maybe I misheard. Why are you waiting on us? Even if we do or don't come through with the funds, I mean, are you still going to go through with this case, or is it that you can't afford to go through with it without our?
It's a great question. I can't afford anything, Dustin, but I'm going forward anyway. The campaign's currently in debt, but I raise money every single week, and I keep paying off the debts the campaign has, and I'm trying to run the campaign. Will I be able to do this without you? Probably yes, but it'll just make my life a whole lot harder. And why would I want to do that? Why would I want to try to keep more people waiting for their money? Why would I want to keep doing it this way when if we win this thing, I'm helping out the LP? I want to be clear on this. We win this thing, or if I get my 130, either way, we're saving the LP $500,000. So we're saving the LP money. So will I do it without you? Probably yes. To be forward with you, probably I will. I probably will. But you're just going to make my life a whole lot harder. And you shouldn't do that because I'm helping out the LP National. So yes.
Let me point also that I've made the offer, and the offer still stands. If you can find another attorney to take this appeal, I would gladly turn it over to that person and even contribute full cooperation and assistance with that appeal. If in that case, this is quite a bit of work, and I'd be happy to do it.
No, Gary, stop. No, you're the guy who brought us across the finish line last time. You're the guy to bring us across the finish line now. No, unacceptable. No.
I'm prepared to do it, and I'd be happy to.
Ms. Gilson of the Ballot Access Committee.
I actually have a couple of questions. One for Mr. Hagopian. He said that there was $71,000 approximately budgeted for ballot access, but made a comment that the revenues are not quite where the budget line had been set. So how much is actually cash on hand available that's not encumbered with day-to-day expenses?
Great question. We have plenty. So we have over $200,000 as of the end of last month in cash reserves. We will likely lose a little money in August, operating expenses versus revenue, which will keep us, probably just below 200. So this would then come out. We typically try and keep around $85,000 cash reserve. So we are healthy right now compared to where we've been for the last year. So that's why I said I will likely end up voting for this, because I believe it's worthy to spend. But I did just want to note that the actual amount left in the budget is really meaningless if the revenue line isn't where it needs to be. So, but yes, we have the money to spend.
Okay, very good. Thank you. My other question would be for Mr. Nana then. Are there other states other than New York that have a less powerful fundraiser that will be requiring funds from the LNC? Right now, Mr. Sharp, I'm a huge fan of Mr. Sharp, and will send you money myself, but I just know that there are going to be other asks of the LNC, and want to know who else can we expect to ask for money if we use some of it now.
Well, it sounds like Pennsylvania is going to ask us for some money right now. But other than that, nobody that I know of at this time, but that could always change. We're not tied up in any sort of actual ballot access drives right now. That should all be taken care of. But a candidate or state could come to us pretty much at any time.
Alabama's going to have an ask. It's going to be, I'm not sure if it's going to fall under the purview of ballot access or candidate support. But they're going to have an ask. It's not going to be, it's going to be less than $10,000.
For my part on the ballot access committee, my suggestion would be to absolutely, if the money is there, it's budgeted, it's not encumbered with any other day-to-day expenses, absolutely, let's give it to them. Let's get more litigious in the courts. Let's not try to pay $5 and $7 for every signature to do it to a tune of $500,000 every time we need a state ballot access. Let's get in the courts and do it that way where we can. So thank you.
Okay, I have Mr. Bowen up next, and just to kind of hint, nudge to the executive committee, that a motion would be appropriate at any moment. Mr. Bowen?
Thank you, Madam Secretary. I have a question for Mr. Nana. Just wanted to know, full transparency, by the way, I am on the executive committee and the ballot access committee, so just so everyone knows that. But Mr. Nana, do you have any information in terms of what the current encumbrances are in the budget category for ballot access? What states and what amounts, or at least a total? And can you confirm that the amount that is the 15,000 is still considered an encumbrance for New York, since we have not paid them the additional 15,000 at this point?
I'm not sure about the New York money, because that was a decision made by the executive committee at the end of last term. I don't know if they changed the encumbrance amount or what they did there exactly with that. I don't believe I was at that meeting. There's room in the ballot access budget to do this if we want to. And actually there's a specific legal line. I don't know if we've exhausted that yet. I want to say we have not. That's within ballot access. So, I mean, the money is there. That we're not, like I mentioned, we're not currently sending any states any money right now. Could change, but as of right now, like for instance, New Hampshire has already received their money. They've already done their drive. Same thing with Illinois. And Alabama as well. I guess maybe they're going to have a new ask, but I don't think it's going to fall under ballot access since they've already petitioned.
Thank you. Second question to Mr. Sharp or anybody from New York. Who is actually asking for the money at this point? Is it LPNY? Is it the Sharp campaign? How is that money, if we agree to it, going to be dispersed?
To be forward, I don't really care. It's going to a legal fund. So you can send it to LPNY has a ballot access fund, which can be used. If you think that's better for you, you can send it to my campaign. It doesn't matter to me. Wherever you want to send it, the answer is yes, because it's going to go to legal issues. I'm happy to take the income because it'll make it look nicer for me when I report. So I'm happy to take it. However, if you want to give it to LPNY, they have a ballot access committee. That's where I've literally funneled at least $90,000 into the ballot access committee, if not more already this year. You can put more into it. It's totally legal in New York State. You can be done and they can pay for it. No worries whatsoever. So whatever works for you, I'm happy. Yes.
That is accurate. It could come through either entity.
Yep. Doesn't matter.
Okay. Thank you, Mr. Sharp.
Just for the body, up on the screen is the last motion from last LNC from the executive committee. I don't know if that answers Mr. Bowen's question. Mr. Hagopian.
Yes, prior to somebody making a motion, I just wanted to ask a similar question to Mr. Bowen, and maybe Mr. Bowen, Secretary Harlos, and Mr. Nana could chime in if necessary. Basically, we have plenty of money also in the candidate support bucket. The reason I'm bringing this up is we don't know if it'll cost $15K to do this, but I think $15K should go. And what I think is if it costs 10, then 5K can go towards the write-in, which helps us also. So would it be legitimate to do 15K out of candidate support to Larry, knowing that Larry is going to fund this lawsuit? It's just a question for folks who have more LNC experience than I.
I think you can send it wherever you want to send it, or take it from wherever you want to take it from, rather. I mean, putting my ballot access hat on, I'd rather you not take it from our fund if you think that you can finagle taking it from somewhere else that may not be being utilized right now. But I mean, as the treasurer, I don't know. It's also going to be kind of up to you as to what you think best practice would be. I mean, there's a lot of blurred lines here. I mean, it is candidate support, but it also relates to ballot access. So an argument could be made either way.
I believe Ms. McCardle wanted to chime in.
Put me on deck after Mr. Elliott.
Okay, Mr. Elliott.
I was going to make a motion. I'll yield my time to the chair if she would. No, okay. I would like to motion that the LNC authorizes the distribution of $15,000 to the ballot access, or well, I don't want to put constraints around it. Motion that we approve the spending of $15,000 to support Larry Sharp ballot access in New York.
Second.
One moment, just as a point of order, the motion's not complete. You do need to specify in a money motion what budget line it's going to come from.
Then I would add that the budget line would be ballot access.
Second.
Okay, so let me make sure I have your motion correctly. It's that the LNC approved distribution of $15,000 from the ballot access budget line to support the Larry Sharp campaign.
Correct.
And it was?
Well, to support the Larry Sharp ballot access efforts.
Okay,
yes.
So.
Yes.
One moment, let me reread that. So it's the LNC to approve distribution of $15,000 from the ballot access budget line to support the Larry Sharp ballot access effort. Is
Agreed.
That accurate?
Yes.
Do you need to speak to your motion, Mr. Elliott?
I think it's a great idea, and I think New York is very important, and there are national implications. And I think it's a sound investment of our members' donations.
Okay, is there any further discussion or debate on the motion, Mr. Bowen? Oh, Ms. McCardle, and then Mr. Bowen.
I'll just say that I'm in favor of it. I think this is a financially responsible decision, and I think it's a good thing for us to do for LPNY and Mr. Sharp, because they've all worked really hard already. And I also think that Gary is an excellent attorney, and I think his work is great. That's all.
Mr. Bowen?
Thank you.
Thank you, Madam Secretary. I doubt that anybody on the executive committee is going to argue against this or try to determine that maybe we should pay a little less because it'll cost a little less. I am in full support of this for the one and very reason that we have already encumbered $30,000 to New York at prior term, of which I was a direct part of. Working at the Boston meeting with Mr. Ford and with the Cordovas and Mr. D'Orazio. I believe this is the minimum we should be doing for New York at this point. So I will be in support of the 15,000. Thank you.
Mr. Smith?
Yeah, this is a great motion, great people involved. We're righting a wrong from last term. Let's just get this thing done. I call a question.
I know. Okay. On small committees, you actually can't. Okay, but that's fine. Is there any for does anyone else wish to speak? Okay, no one else.
I just wanted to be on the record as calling the question. That's all.
Okay, well, there's no further debate. So that's what we would go to.
Perfect.
Anyway, so this is a vote just of the executive committee. Mr. Bowen.
Yes.
Second, Mr. Elliott.
Yes.
Mr. Hagopian.
Yes.
Mr. Nikela.
Vote aye. Give them help, boys.
Mr. Smith.
Absolutely.
Ms. McCardle.
Chair is not voting.
And even though I was just subbing in, I am going to vote yes. So it is 6 yes, 1 express abstention, and I'm passing the gavel back to Chair McCardle. Motion passes.
Thank you very much, everyone. Silent clap and no reactions. There we go. Woo. Okay, let's move on to our next agenda item. I really appreciate the patience of everyone in LPPA sticking it out with us. Rob Coburn had to drop off. There are 2 people who are going to fill in and discuss. Allison Graham is one, and I butchered the name that I was writing down. I thought it was Mr. Schwartz, but I could be wrong. But if I know that Allison Graham is on the call. If you or your other LPPA legal representative would like to chat about your case, I would turn the floor over to you for about 15 minutes starting now.
Thank you, Angela. And I'm actually going to turn this over to Richard Schwartz to take the lead here.
Thank you, Mr.
So he should be online.
Okay.
Second here. Hi, everyone. Okay, so we have 2 court cases, and I know TJ is on the call, and he can probably talk a little bit better about the case with his wife, Brittany. But mainly, we're talking about, or the case I'm talking about is Caroline Avery, who is our candidate for Congress in the 1st PA congressional district, running against Brian Fitzpatrick. And we think Caroline, if she can survive staying on the ballot, can really make some positive inroads for the Libertarian Party and could possibly upset and get Fitzpatrick a pretty major loss. But anyway, the court case is based on the Pennsylvania sore loser law. Caroline's campaign turned in 4,800 volunteer signatures out of the 14,000 or so that we turned in statewide. So a significant effort from herself and her team. You know, we had other candidates in that area. She alone collected over 2,000 signatures. I mean, we certainly want to keep Caroline active and happy in the party. We would love to have her run again in 2 years and also contribute 4,800 volunteer signatures to our campaign. So as we predicted, her case got challenged based on the sore loser law. And what happened was she attempted to run in the primary election, in the Republican primary, but withdrew. You know, the reason why she withdrew isn't necessarily important according to our lawyer. The fact is she did withdraw, and there's a presiding case that he actually argued years ago that says that if you petition a judge and you're allowed to withdraw, and with no strings attached, then you would be eligible to run in the main election with either as an independent or another party. So we argued the case in Commonwealth Court. Unfortunately, we lost that case, but our lawyer is really anxious to appeal this case to the state Supreme Court, where he's been victorious before. He argued the presiding case in this whole thing. And so just, to cut to the chase, money-wise, the state party has approved $5,000 for Caroline's legal expenses. We've spent $3,000 so far, so we have $2,000 remaining. Our lawyer seems to think it could come to an additional $5,000, so for a grand total of $8,000. So I think in Caroline's case, we'd be looking for $3,000 to $4,000 to help us fight her ballot access challenge in the state Supreme Court. That's sort of all I have to say about that. I don't know if TJ wants to make an argument for, his wife who's running in a different election, challenged on similar grounds, but slightly different.
So I would like to hear about Brittany's campaign, and then I'm going to have a few questions, and then I imagine someone else will too.
So Brittany's campaign, she's actually, we've done independent polling. We actually have a campaign advisor who's done that polling. She's actually polling ahead of the Republican in the state Senate, state representative district. She's ahead by 3 points in a +6 red district, which means that, in essence, the Libertarian Party, if she could survive this, would gain an actual Libertarian in our state legislature, which we don't have currently. We have one independent in the state House and Senate. We hired Scaringi Law. They represented Trump. Jeff Schatz, very well respected in the campaign law community. His case is more on the grounds that Section 5 and 6 of the Election Code of Pennsylvania is completely unconstitutional and possesses an unfair disadvantage to minor party status candidates. It also does not allow the people of Pennsylvania to vote for their candidate and have true, free, and fair elections. He's also going to be fighting the fact that the judge in the initial case in the Commonwealth Court initially wasn't even going to allow Brittany to speak at all. And then when Brittany tried to go in the details, they wouldn't grant her continuance. They lumped her case in with a federal case when she's a state candidate. There were several procedural things that he felt that he can contest that for an appeal that they violated in the Commonwealth Court.
You froze there. Okay, TJ's frozen. Allison, why don't you jump in for a second here till TJ's Wi-Fi comes back?
Sure. I just wanted to give a little background on the two candidates because this is a very, these are two internal races in Pennsylvania. Both are from Bucks County, Pennsylvania, which is one of the two remaining original counties of the Commonwealth of Pennsylvania. For those that don't know their history, this is where Washington crossed the Delaware. We look up to our liberty here, certainly outside of Philadelphia. One of the most important things I think to note here is that Brittany's campaign for House District 178, which is for our state house, if she and Caroline are successful with remaining on the ballot, because we have somebody running for state Senate as well, we have a possibility of seeing a ballot in this one district with Libertarians listed for every main office, all the way from our gubernatorial candidate to lieutenant governor to U.S. Senate to first congressional district. And I should know that Caroline is the only person that continued to attempt, and is still attempting to the very end here, to be a U.S. House of Representatives member. There are 18 in Pennsylvania, and she would be the only one across the state for Bucks and a sliver of Montgomery County here, as well as our state Senate and our House rep. So it represents a very unique opportunity to have Libertarians as a possibility for all voters in this very, very dense, in this very dense county here in Pennsylvania, and specifically into the 178 district. So I just wanted to thank the LNC for taking the time to consider this. We know it's very specific to Pennsylvania. TJ, I'll turn this back to you in a moment. And certainly, we feel tremendously for our neighbors to the north in New York for what they're going through with ballot access. So thank you for your time, and I'm going to turn it back to TJ to conclude his statement there.
Okay, TJ, I
Sorry about that. I don't know what you heard up to.
I definitely heard you saying that it was right for a Supreme Court case, that the law was unconstitutional. And then you made a couple other comments and then we lost you.
Yeah. So he's also contesting that because the Commonwealth Court judge was not granted continuance under common rules for continuance, being that she worked as an emergency room registered nurse, that she violated her due process. And by lumping a statewide state candidate's case in with a federal case, you're not giving her a fair chance to defend herself. The judge also basically not even over. She was going to allow Carolyn to do all the
Yep. We're losing you again. TJ, are you on this?
Can you hear me now?
Yeah, that's better. Except, wait, did he just disappear? Oh my gosh. Okay. Do we have anyone else who wants to speak on Pennsylvania? Because what's going to happen is I'm going to ask questions and then it's going to go to Brian Elliott and Dustin Nana. Oh, TJ, you're back.
Yeah, sorry, my internet's stupid downstairs.
Okay.
So basically, they didn't give her a chance. They weren't going to have her speak at all.
Okay.
She had to actually speak up to be able to be addressed by the court. So they basically didn't let her present her case at all. So that's her grounds for appeal.
Okay, great. Anybody else from Pennsylvania who is actively working on this case or working with the candidates have anything to weigh in before I start with a couple of questions? Still got a few minutes. Not okay. So TJ answered some of my questions. I read through the case law. I actually gave a copy of it for the In re Cohen case for people in the LNC to take a look at. I was a little bit concerned because I thought that Carolyn Avery's case, it seemed like the most challenging. Brittany's case seemed a little bit easier, but your TJ has given me some new legal angles to attack it. I like that you're trying to allege that the entire thing is unconstitutional. Can you tell me, is it unconstitutional, do you think, at a state level or at a federal level?
The attorney feels it's more on a state level because our state legislature is supposed to pass the election code.
Okay.
But our state Supreme Court tends to try to play politics a lot.
Okay, so where did the election code come from if it didn't come from the legislature?
It did, but the verbiage is being interpreted by the court. So on our petitions, it says that in order to file, that the Secretary of State has to accept your signatures. Okay. Which did not happen in either Caroline or Brittany's case. They were objected to, they withdrew. Yep. So the Secretary of State never had a chance to accept. So therefore, no signatures were actually filed.
Okay, which candidate signed the stipulation to not go forward? Was that Brittany or Caroline?
I believe they both did.
They both did. Okay, I know at least one of them did. Next question, which I do not mean this in any disparaging or negative way. Do you think either of them are going to blow out and quit the party if they don't get funding?
Brittany is not. Brittany plans to fully run again in 2 years as a Libertarian.
Okay, good to know. Not trying to throw shade. I just want to, get everybody's information. Okay, who had a question? Is that a Pennsylvania person? If not, I think we need to hop on to Brian Elliott, and then I don't recall if it was Ms. Harless or Mr. Nana next.
All right, I don't want to waste too much time on this, but I'm just curious with the comment that you're polling ahead of the Republican. As someone who was born in Bucks County and raised there, I'm interested in, and I saw the map and where y'all are located, but I'm just, how reliable, how much confidence do you have in the poll?
I'm fairly confident since the GOP, and we do have connections still within the GOP that feed us information. There's a big rift within the Bucks GOP. Pat Poprick is the head there. She's been the head for 20 years. She's very corrupt. And there's a group of people trying to oust her, so they been feeding us information, which works out good for us. But they did their own poll from their door knocking, and they had us ahead +2. So our polling, we did it from canvassing we hired some people through our advisor, and he had them door knock and ask questions on who they would vote for. There's also several independent voter groups where Brittany's polling ahead of Kristen. Kristen's not very well liked. She was a school board candidate for Council Rock. She's currently on the Council Rock school board. She only won her race in November by 1 vote. And it had to go through the courts because the Democrats were contesting it. So she's blocked some constituents that called for a debate between her and Brittany. The Democrats really he thinks he's running for state rep to help Ukraine. So he's kind of non-factor. State House can't help Ukraine. So that's kind of where it came from, that we're ahead in the polls.
Okay, so how is it that you've created awareness of the Libertarian brand sufficient to show up in a poll?
Brittany's very active on social media. She goes to every event. We're also very active in the community. Brittany's a volunteer firefighter. I'm a past fire chief. She's an ER nurse. She's also an EMT, emergency medical technician, for anyone who doesn't know what that is. So we're pretty active in the community, whereas Kristen barely shows up to school board meetings. She doesn't show up to a lot of fundraisers. She shows up to the high-end GOP elite stuff and doesn't show up to any of the average Joe people who are going to vote.
All right, so just to be clear, so this looks like the rank and file Republicans increasingly seeing their professional Republicans as being acting contrary to their interests as citizens, and they are therefore becoming more aware of and supportive of the Libertarian point of view. Is that a fair summary?
That's a fair summary. The big contributing factor is guns. This area of Bucks County, the 178th, has a lot of gun owners, and they've seen a lot of the Republican candidates cave on gun control. Brittany was the first candidate of the Libertarian Party that was endorsed by Gun Owners of America in Pennsylvania this cycle.
Yeah, well, the first day of hunting season, they didn't open school in Upper Bucks County because half of the boys were not show up. So that's an interesting point there. Thank you for indulging me. I'm done with my questions.
Okay, who's next? It's
Mr. Nana.
Okay, Mr. Nana, and then it'll be Ms. Farlos.
Okay, what, I think we've heard like a broad overview. What is the specific ask of the party in terms of a monetary amount? And then my other question was, I heard it mentioned briefly before we started the meeting during public comment, something about sore loser laws, and maybe I missed this in the explanation. How does sore loser laws tie into this issue? Because I know that sore loser laws have been held up virtually everywhere across the country, unless this is some specific quirk related to Pennsylvania that I'm not aware of.
So on the Brittany side, Brittany's argument is different than Caroline's. Caroline is strictly focusing on Cohen, but Richard can get more into that. On Brittany's side, we're focusing on the fact that on our petitions, it states that the Secretary of State has to accept your signatures for it to be filed. And under Section D or E, I believe it is, it says that if you filed petition signatures in the primary, you can't run in the general. So if they weren't accepted and they were withdrawn in court, then nothing was filed. And that's where we're getting around the sore loser. They're trying to cite Burkowski as the case they're trying to cite for sore loser. The lawyer for the other side threw out half his case within one sentence of the court hearing, but yet the judge still chose to rule on that. He said the issue of voluntary or involuntary withdrawal doesn't matter. As soon as the judge asked him, "Are you sure you want to throw out half your case?" And he said yes. So that shouldn't have been in the ruling at all, but it was in the Commonwealth Court. And then Brittany's campaign's asking specifically for $5,000.
And I can answer regarding Caroline. Her case, as I understand it, and I'm not the expert, it's based on the withdrawal itself. The sore loser law applies if you file to run in the primary or, certainly I'm on the primary ballot, but there are presiding cases that if you withdraw, certainly if you withdraw by the deadline to withdraw, then it's almost as if you never filed in the first place and you're able to run in a general election. In Caroline's case and the Cohen case that preceded it, that everybody's talking about, the candidate petitions the court to withdraw and the court allows them to withdraw. They're treating that the same way. There's no stipulation on why the candidate actually withdrew. So I think that's where, you know, our attorney in Caroline's case really thinks he's got a good shot at winning this in the state Supreme Court level. And we're asking for probably up to $3,000 to $4,000. You know, I would say up to $4,000. It probably wouldn't go that high, but I would say up to $4,000 to complete the defense of Caroline's case. Keep in mind the state party has already contributed $5,000. So this would be in addition to what the state party is contributing, just so that we can continue on with this.
So that was 5,000 from one candidate and up to 4,000 from another. Is that correct?
I believe so.
Okay.
Correct. Yes.
Okay. Okay, Ms. Harlow's is next, and then I have, actually that answered my question, then it'll go to Mr. Hagopian.
Okay, I don't necessarily have a question though. You know, my ramblings sometimes turn into a question. In general, there was a comment in chat earlier that I agree with, that we need to start fighting these more on the legal fronts. So I'm always inclined to support that, but this is more an exhortation to the LNC in general, that if we do, I really do think we need to start making a lot more noise about it. I don't think we should only be viewing these as are we going to win this case or are we not going to win this case? I think we need to view them as fundraising opportunities, but also PR opportunities. The idea of voter suppression is such a big deal nowadays that I don't think we beat that drum enough. And I think we should be using these cases to do that. So I'd like, you know, just the LNC to keep that in mind. Larry made a really good argument about that in the New York case as well. But if we just do these cases and no one hears about it and we know they're long shots, that's kind of throwing money away. You know, you need to, like the government does, don't ever let a crisis go to waste. We shouldn't let these cases go to waste. And I'm curious, it did lead to the question. With the fact that this is colloquially known as the sore loser law, I think it makes it pretty obvious what the intent was. And I know that courts aren't always likely to go look at the legislative intent, but someone who didn't even run in the primary, they didn't lose. I mean, to me, it should be fairly obvious. I think that should be a somewhat strong argument that election laws have to be tailored to protecting some kind of public interest. And they claim to have a public interest in not having somebody have multiple bites at the apple. But if you never even put the apple in your mouth, like what public interest is being allegedly protected here? And I'm wondering if that's an argument at all in this matter.
Well, I can answer as our attorney agrees with you 100%, Caroline, on each one of your, or I'm sorry, I'm getting you confused with our
Don't worry
candidate,
about
Caroline. Our attorney agrees with you 100% on both your points. You know, Caroline, our candidate, has been harassed by Fitzpatrick and Fitzpatrick's people. And our attorney thinks that she should be making a lot of noise about that. And something else that he wants to consider is possibly, you know, filing a lawsuit against them for their techniques, for their harassment techniques. And he said, you know, we should have a press conference about this. But, you know, it takes more action to make that happen. And, you know, the other point, yeah, he made that case very eloquently in Commonwealth Court, too, about protecting the voters' rights to, you know, have a chance to vote for candidates to get on the ballot, you know, who are on the ballot. And, you know, agrees 1,000% that if they don't actually run in the primary, but, you know, it's the technicality of how the law is written and how the law has been, you know, defended and protected over the years. But I think it's a very, you know, good point.
And I agree to that point with Brittany. Brittany actually issued a press release regarding it. And I believe Angela shared it on Twitter. So we're trying to get it out to as many people as can be. Brittany's also had to file police reports because she received death threats from known GOP committee people.
Yikes. Okay, let's, I think the next person on deck is Mr. Hagopian.
Okay, rapid fire quick questions here. I just want to make sure facts are on the table and I understand them. These were people who began to run as Republicans withdrew and are currently running as Libertarians, not independents. Is that correct in both cases?
Correct.
Okay. These two races have no bearing on state ballot access. Is that correct?
Correct.
Okay. The state party contributed to one candidate, which was which one?
Caroline, I believe the state party has contributed to both candidates. Isn't
It
that correct?
contributed to both, correct.
Okay,
Brittany's getting 3,000 from the state party.
Okay, Brittany got 3. Do we know what Caroline got?
5,000.
Okay, wonderful. So from a treasurer standpoint, just the cautionary spot here is there's hundreds of people that run for office every cycle. You know what I mean? And if we're funding all of them when they have trouble getting on the ballot, we're going to run out of money real fast, especially when they don't have bearing on state ballot access, etc. On the upside here, if we do even get a single win, to Dustin's point, against sore loser laws, that potentially helps us down the road. That would be a huge deal. And if the polling is anywhere near correct, that is a big positive, obviously. And then also, I'm more inclined to do something like this if state party has already shown willingness to back the candidate, so that it's not just a crossover candidate that we're trying to win with, but they're also throwing money behind. So thank you for answering those questions.
Okay. Dustin, go ahead. I have a couple of questions about ballot access.
Okay, very quickly, this does not affect state ballot access. So my ask of the executive committee is please don't take it out of my budget. Please take it out of candidate report.
Okay, so let me ask, I would like to ask a little bit more about ballot access. What's the party status right now in Pennsylvania?
Right now, we're a minor political party.
Okay.
That doesn't really give us very much. We sort of get that and lose that every 2 years.
Right.
We have to petition every year. There's no mechanism for us to maintain ballot access from election to election. We always have to petition.
What's it take to get major party status?
15% of registered voters.
15% of registered voters.
Yes. To be registered.
To be registered Libertarian.
Correct.
Ugh. Okay.
Yeah.
Okay. Todd, what's our budget line for candidate support?
I think we have about 180,000 left. Let me look real quick. I mean, it's something ridiculous, but we don't have.
Yeah, but there's staff salary. Or I don't know if there's staff salary, but I think there's contractor salary that comes out of that.
Yeah. I mean, we have enough to do this, but again, we just have to be careful with what we spend.
Okay. So I'm not making any motions. I'm gonna ask, is there a number that people feel comfortable assisting with? And if there is that number, why is it that number? Anybody on the executive committee chime in?
Okay, I'm sorry. Rich actually was polite and raised his hand, but nobody had their hand raised and I kind of jumped in.
It's fine.
I'm a little iffy. I've just seen or heard, and maybe it's just a little bit of my, oh, look, a bird, and I zoned out for a moment. So please forgive me if that's the case. I'm hearing figures, but I'm not hearing action. Like what will be done with those figures? Like with the New York thing, it's going to cost this much to file a lawsuit, and we're going to file a lawsuit, and we are hoping it will go to the Supreme Court. Like there was a path. I'm hearing a lot more generalities here, like $5,000 to assist in this, but exactly how are we assisting in this? I'm all about ballot access. I always have been, but you can't just throw money at a problem. So if I miss that, that's where I'm a little bit unclear. So I can't really say where I'd be comfortable because I don't really know what we're doing. I feel bad and want to help.
And my understanding is it's for legal fees.
Okay.
Correct.
Yeah,
It's Brittany has 10,000 in legal fees that she's going to need. She has 2,000 covered from herself. She has 3,000 from LPPA, and she needs a additional 5.
Yeah,
Okay,
and
my
in,
apologies if that was said and I somehow missed it.
yeah, and in Caroline's case, we already spent $3,000 on the Commonwealth Court case for our attorney. I've spoken to him directly about what he thinks the appeal to the state Supreme Court will cost. He thinks it could go up to as much as $5,000. I wanted to leave a little more wiggle room if in case it goes a little bit over that. The state party still has another $2,000 to pay for it. So it would mean a total of $8,000. So in theory, we could probably get away with $3,000 from the national party to complete the legal fees for Caroline's challenge.
Good to know. Mr. Bowen, go right ahead.
I'll yield. That was actually, Ms. Harlow's had the same question I did. I'd like to get a little more of a specific answer as to exactly, what they're asking and what they're planning on doing with the funds before, before I would agree.
So 3 and 5 to cover legal fees.
Yep.
And
the court cases are
Cosin.
get these 2 people on the ballot, on the general election ballot, correct?
Yep.
Okay, thank you.
Yep. Okay. I think we've got Mr. Elliott and then we've got Ms. Harlows.
Quick question was Brittany, why did it appears, I just looked at Ballotpedia, she did not actually run in the Republican primary. Was that her decision or was she disqualified by the Republican Party or some other process?
So they contested her signatures, but she withdrew before it even went to court because the Republican Party actually offered her a backroom deal that if she dropped out of the race and endorsed Kristen, they would allow her to run for the Bucks County Commissioner seat, and he's retiring next year.
Okay, thank you.
Okay, next up, Ms. Harlows.
Okay, I'm going to ask a question just because I think this will probably be on somebody's mind. I'm not saying this is a big concern of mine, but I'd like it just to be on the record. To be a little mercenary here, is one of these cases way stronger than the other? Like, do they, I know the wish is to pursue both of them, but is it better to put more eggs in one basket?
It really depends on who you talk to. Different people associated with the 2 cases are going to have different arguments. The attorney for Caroline's case thinks he has a really strong case. He didn't want to take Brittany's case, but I don't mean to disparage Brittany's case, and TJ can, I'm sure, speak to that. They're
I think
on different grounds. So, I think they're both interesting cases in terms of, the possibility of winning. I don't know.
And I think both cases should have never been brought together. I'm pretty sure both attorneys agree with that because one's a federal candidate and one's a state candidate. And in Pennsylvania, we can't even campaign together. Yeah. Like Brittany can't get funds at an event jointly with Caroline. Like they have to be separated. Otherwise, we're violating FEC laws.
My personal opinion is that I thought Brittany's case seemed stronger, but Allison and Richard have made some points about Caroline's case as well that I hadn't considered. Mr. Hagopian.
2 quick notes. So first of all, based on what was just said, they should probably be broken into, and probably would have anyway, but should be broken up into 2 motions so we don't run afoul of any Pennsylvania laws. Having both on the same motion. Second thing is we spent considerably more than this trying to get a state house candidate elected in the past when they had a reasonable chance of winning, which is the candidate that supposedly has the polling that's that close. Is that the Brittany?
That is Brittany, correct.
Okay.
And it all boils down to guns in Pennsylvania. Everyone wants to keep their guns. Now, Brian did vote for the AR-15 ban, the assault weapons ban, or whatever they want to call it, which Caroline is a staunch against. So that also helps her as well.
Yeah, I just wanted to make that make that point that in the past we have spent considerable funds going after state house wins when we thought we had even a sliver of hope. So just a thought.
Okay, anybody got any questions? Anybody want to make a motion? Anything else? I guess I'll ask a question. When is the next court hearing or the next filing fee due? Whatever the next legal action.
Richard, I think
is.
it's Tuesday, right, Richard?
Well, in terms of Caroline's case, the Commonwealth Court has heard the case, has already decided. So it amounts to filing an appeal in the state Supreme Court. So there is no specific date set up. Our attorney said that once he files, they'll give him a briefing schedule and they'll basically set the schedule at that time. But currently there is, we haven't filed the appeal yet. We're waiting to see if we can pay for the appeal. And then once we do, he's going to go hog wild and go full force on it. And then he'll get the actual briefing schedule.
And I know Brittany's attorney wants to file the appeal by Tuesday.
Okay.
Yeah, our attorney wants to file it tomorrow, possibly even tomorrow, if he can get it done in time. He said he would work on it most of the day tomorrow and try to get it filed, certainly by next week.
And when does it actually due?
I don't know that answer, to be honest with you.
What's that?
I don't know specifically. It comes down to, how late the Commonwealth can accept changes to the ballot. These cases can go, I've seen cases go into October before, but they start printing, it all comes down to when they start printing ballots, they start sending out the absentee ballots and stuff like that. So, we obviously want to do it as soon as possible because I don't think there's a necessary deadline, but sometimes, once they start printing the ballots and all the other stuff that they do, there's no real turning back on that.
And are you filing a temporary injunction or a request for a TRO or declaratory relief, something of that nature?
That has not been discussed with me.
Okay.
Brittany's attorney is filing a motion to set aside the Commonwealth Court's opinion pending the appeal.
Okay. I was just curious what it was and what the timeline was. Okay. Todd, did you have anything else?
Yeah, please remind me what the Brittany ask was again.
5, I believe.
Brittany needs 5.
And
I would like
Carolyn
to make a motion if it's permissible.
Yeah.
I would like to make a motion to expend $5,000 Brittany, insert last name, from the candidate support line item.
Okay.
What is Brittany's last name?
Kosin, K-O-S-I-N.
Okay.
Same as mine.
Oh, gotcha.
Second that motion.
Okay, so it's been moved and seconded.
Will you please repeat your motion, Mr. Hagopian? I'm sorry.
Motion to expend $5,000 to support Brittany Kosin from the candidate support line item.
Gotcha. Thank you.
Okay, any discussion on the motion? Once, go twice. Okay, well, we need to do a roll call vote because this is money.
Okay.
So go right ahead.
Mr. Bowen,
Yes.
Mr. Elliott,
Yes.
Mr. Hagopian.
Yes.
I will vote yes. Mr. Nikela,
Yes.
Mr. Smith.
Yes.
Okay, Madam Chair, are you going to vote?
No.
It is 601.
All right. Motion passes. Thank you, guys. Okay. Any other motions on this agenda item before we move forward?
Yes, Madam Chair, I'd like to make the parallel motion for the other candidate, but change the amount to, I believe it was 4,000 was the ask, and it was for Ms. Avery.
Carolyn Avery. Her ask was 3 or 4.
I am making the motion for 4,000, so it would be to Move to expend $4,000 to support Carolyn Avery. And from the candidate support line again, unless Mr. Hagopian tells me we don't have that in that budget line.
You're fine.
Okay. All right, it's been moved by Ms. Harlos,
Second,
and it's been seconded by Mr. Elliott. Any discussion on this motion?
If I may, the only reason I'm going to change my vote on this is the lack of, I guess, lack of likelihood of winning or evidence that that is a sincere possibility. So I think that when it comes to state house races, which we run hundreds of across the country, that should be one of the barriers that needs to be cleared in order to get LP funds. So as treasurer, I'm going to vote against this for that reason.
Okay, any further discussion?
Yes, Madam Chair.
Yes, please go ahead.
Not to sway Mr. Hagopian, just to put my views on the record, though if I swayed him, I would be pleased. When I vote for these things, I don't do it based on likelihood of winning. It's great if we win, but let's be honest, we normally don't. I do it based upon, we need to start fighting the bastards back. That's what I base it upon, and how else we can use this to further our overall party goals. This is way beyond the candidate to me. And this is why I'm going to support this and why I in general support these, even if we don't think they're going to win.
All right, Mr. Elliott.
refresh my memory, and I apologize. So is this Avery legal case also potentially, precedent setting? Is there a legal doctrine that this will help the party?
Yeah.
Yes, that was my understanding.
Yeah.
Okay. Okay, I'm done. Thank you.
Mm-hmm. To clarify, my understanding is that the attorneys are arguing that if they overturn the sore loser law in Pennsylvania, which they believe to be unconstitutional at the state level, if that were to be also appealed to the Supreme Court or be referenced in a court decision, perhaps in a circuit court in another state that's referencing Pennsylvania law, it could help to overturn sore loser laws in other states and it make it easier for us to get our guys on the ballot. That's the argument that was put forward. Any further discussion on the motion? Once, gone twice, 3 times the motion. Okay, Madam Secretary, if you don't mind, would you please do roll call vote?
Mr. Bowen?
Yes.
Mr. Elliott?
Yes.
Mr. Hagopian?
No.
I will vote yes. Mr. Nikela?
Yes.
Mr. Smith?
Yes.
Okay, Madam Chair, are you going to vote?
Nope.
It is 5 to 1 to 1.
All right, thank you, everyone. That motion passes. Okay, I believe that takes care of all of the asks on this agenda item. So that should wrap the agenda item. If there's anything else pertinent, let me know within the next 5 seconds because we're moving on to the next agenda item. And we're there. Okay, the last thing on the agenda. Trying to take a look at it right now, I believe is New Mexico.
Yes, ma'am.
Okay, Ms. Harlos, would you like to open this agenda item?
Sure.
In any respect? Go for it.
Okay, and I am probably going to move to go to executive session at some point. I'm just giving a heads up. I might not get there, but I'm just letting everyone know where my head's at. We, as you know, the LNC at the July meeting passed a motion to ask the Libertarian Party of New Mexico, yes, to affirm that their operative constitution and bylaws were the ones that were approved in convention March 27th, 2021, due to the fact that their recent constitutional convention was invalid. They basically wrote back and didn't address any of the arguments, except for possibly one, as to why their convention was invalid. There are 3 grounds that their convention was invalid. Any one of them is sufficient. They're completely severable. The only one that they kind of sort of addressed was the weakest one, which is that electronic conventions were not authorized in their bylaws. They claim there was an executive order in effect and provided a copy, but the executive order they provided a copy of was dated a month after their convention. So I don't think they've met their burden of proof on that. But to be honest with you, it doesn't matter. The things that are completely objectively true are the notice requirements and the fact that they excluded valid voting members. So they've just basically said no, LOL. And so now, unfortunately, it's the ball's in our court, and we have to decide what we are going to do with that. Our chair did write a letter back detailing our position. I don't personally think we're going to hear from them after this. Maybe we will. Maybe we will be pleasantly surprised. And after reading that letter, they'll come back and say, okay, you know, we're just going to do it right. Because the thing is, they can pass all of these simply by noticing a proper convention. It's not that we're saying, you guys heard the arguments from July. So from what I understand, the chair seeks direction on where to go from here. Because again, I might be moving for executive session because this could move into legal areas. So that's opening for the discussion. That's opening the discussion. Then I'm going to say some of my personal opinion. That was the objectives. Now here's the subjectives. I don't think we can just let this go. It is supremely clear, and members' rights will objectively be impacted because one of the changes they made is extending the terms of all of their officers except for the chair. So that means the rest of the officers will not be up for election in the next convention in 2023. The body will not have the option to vote in new officers if they wish. And that is fundamentally a violation of members' rights. Now, some people might say, well, they could just, you know, aren't you just asking them to dot I's and cross T's, and that if they properly notice the convention, they could just pass these things next month? Sure, that's a possibility, but I have to tell you, and this is a personal subjective opinion, I could be absolutely wrong. I don't think if all the voting members that should be allowed to vote are allowed to vote, that amendment would pass. I think it passed because you had a core group of under 20 people that wanted it to pass. You didn't have the whole body. I could be wrong. They could want to extend everyone's terms and, you know, for even longer. But the fact is, the members have a right to make that determination. And it wasn't like any of us were sitting around just watching New Mexico for some reason to go, aha, we caught you. Members in New Mexico, more than I've seen in the other cases we've dealt with, well, except for possibly Massachusetts, because there was almost 40 people expelled, have written us saying, we're at a loss here. When you have leadership that just will not answer to the members on basic member rights, and the fact we have to know as an LNC what their governing documents are. The governing documents is a contract between everybody. Like, if we don't know the basic terms of who the chair is, which isn't in dispute, but I'm just saying one of the things we have to know, and what their governing documents are, we don't have an affiliate relationship. So what we need to do I don't know, but I don't think doing nothing is an option. So some of the things that are on the table are writing a letter to the Secretary of State, letting them know that in the National Party's opinion, our affiliate, the Constitution and bylaws that they filed are not what we recognize. There's also potentially an official complaint with the Secretary of State, but that could involve legal issues. And there's the nuclear option, which I am not in favor of at this point. But I have to say, I'm trying to be honest with the executive committee and the watching LNC as to what our options are, is obviously disaffiliation. I don't believe from going from 0 to disaffiliation. I think that's terrible. So if there are interim steps we can take, I think we need to take them. But I think taking no steps shouldn't be an option. But obviously, that's going to be up to the body.
Okay, so I'm gonna make a couple comments and then open it up. I'll tell you what I am comfortable with right now, and what we don't need any kind of motion for is for me to write letters. I can write letters all day long. I've written 2 letters. Don't know how effective it is. Obviously, now I can write a letter to the Secretary of State letting them know what we're doing. I'm essentially just informing them of what's already happened. That's not me taking any type of new action. It's not me going rogue. Happy to circulate letters to you. Anything beyond that, I would want the support of probably the whole LNC. So just throwing that out there, I mean, at least the majority, winning on a motion. So let's go to Mr. Pankey.
Thank you, Madam Chair. I just wanted to comment on the available options that we said available to us. We've talked a lot about, being able to add and handle these things within nationals bylaws, and also talked about the disaffiliation option. I think that if we go down the road of trying to intervene with secretaries of state in the state organizations, then we're kind of sticking our nose under the tent of getting involved in state action and state affairs. If this body fully agrees in supporting LP New Mexico national members' rights, those national members can feel free to ask for advice, from the LNC on how they would go about petitioning. And just ask as a ministerial or clerical exercise, or for parliamentary opinions or legal opinions. Maybe not necessarily an official legal counsel, but on a general legal opinion as to how they might move forward in the state of New Mexico. But once the LNC gets involved from a party standpoint in trying to make declarations about who is the official affiliate in an area where it is not absolutely clear, where the organization in question is not absolutely clear who the affiliate is in question, then I think that we're, treading dangerously on saying that we're just going to get it, that we are the arbiter of what the states end up doing at the end of the day. And I don't think we should go anywhere close to that. Thank you.
Thank you very much. I believe next up is, let's do Mr. Elliott, Mr. Bowen, and then let's come back to Ms. Hartlos after they get a chance to speak. Brian, you're muted.
I believe that we should, as a body, consider the big picture on how to deal with these. And in my opinion, if we have evidence that the membership is being thwarted, which in this case it seems very clear that they were, and that a new the new entity claiming to be the rightful Libertarian Party of a given state, if we can determine that they did not follow the bylaws and did not let the membership know that there was a meeting, that we're perfectly within our rights to protect our members. I think that's what our primary job is, in addition to moving the organization forward, is to protect the rank and file membership. And from everything I have read and seen, it appears clear that this is a another one of these situations where a handful of people finagle the rules and don't alert their enemies, their political opponents within the state that they're going to have a convention, and they steal the election. And I think we need to strongly respond to situations where it is clear that that's what's going on. And in my opinion, with that, based on everything I have read about this situation, it seems clear to me that that's what's going on. And I would change my mind if I saw information to the contrary, but I have not yet seen that. So I think this is something that we should get involved with, and we should do it under the guise of protecting the rank and file membership of a state where a clear subterfuge has occurred. Thank you.
Thank you, Mr. Elliott. Let's go to Mr. Bowen and then Ms. Robbins.
Thank you, Madam Chair. Question, Madam Chair, for you. If we go the route of writing this letter to the Secretary of State, as I'm not a legal person, two-part question. Number one, what would be the purpose of doing that? And number two, how many or what outcomes would you expect from such a letter in fixing this problem?
Okay, so that's a good question. So if I write them a letter, it's essentially going to be like, this is what we voted on, this is what we decided regarding the status of the Libertarian Party of New Mexico. I can't tell them necessarily do this, do that. I could, it doesn't mean they're going to do anything. They had made some comments. By they, I mean Mr. Lucchini on behalf of the party. I think it's been a while since I looked. I've made some comments about a deadline coming up. Ms. Harless, do you remember what the election deadline was?
This is something foreign to me. I'm not sure what you're referring to.
Okay, so there's some particular issue coming up with the Secretary of State. And if there were any members from the New Mexico LP on this call, they would fill us in. I see Tyler Askin on the call.
Hi, yeah, I'm not aware of any specific deadline in regard. Oh, yes. Unless you're talking about that they had to file it with the Secretary of State and there was going to be a timeline in which that the Secretary of State would acknowledge it.
What's it?
It seems like they've acknowledged their submitted constitution and bylaws that they've enacted. So that is done. We've already seen the letter. They posted it on their website along with the response to the LNC, and it's the PDF of the Secretary of State acknowledging that letter. So that deadline has passed, is what it seems.
Okay, so to that point, I can write the Secretary of State a letter saying, by the way, I saw you did X, Y, and Z. For the record, we are the national party. They're affiliated with us. We made a ruling, and our ruling was X, Y, Z. To that extent, that's what we would do. Now, the ramifications of that are that maybe they'll reconsider. Maybe they'll reach out to the New Mexico Libertarian Party and ask them for clarification. Maybe they'll tell us they don't get involved, which is something that was hinted at it was more than hinted at. It was stated explicitly in some of the Oregon cases, and then eventually the court did get involved. But what they said was, we really don't want to get involved, including the Secretary of State. We don't like doing it. Please sort out your own drama. So we would really just be putting it on the record, and potentially the Secretary of State could take action on it. I don't know. I'm inclined to think they're not likely to do so. But in the event that litigation comes up later down the road, and I'm not even saying the litigation on our behalf, in the event that other members end up suing, and there have been comments by a handful of members in New Mexico, they have that on the record. There's all kinds of other ways that it could go. Like, I hate to give you the typical lawyer answer, which is it depends, but it really does depend. It's kind of helping to preserve the members' rights. I guess that's a good way to answer it. Does that help?
Yes, thank you, Madam Chair.
Okay. And I don't need a motion to do that because I'm not doing anything new. I'm just typing up a letter, sending it out. Okay, who's next? I believe Ms. Harless is next.
Yes. I agree with the chair that the LNC's already passed a motion that recognized that we believe their convention is invalid. I don't think the chair needs a motion to send anything to the SOS. And I think if the LNC wanted to prohibit the chair from sending something to the SOS, that would require a motion. I think it's fully within her scope of authority. But here's the thing. We have an affiliate relationship with New Mexico. We know that they did something improper, and even within our own principles, I don't like using such a strong word, but it does apply here, fraudulent upon their members. If we don't at least document this with the Secretary of State, we are aiding them in this. And I think ew, gross as well, when you mention the state of anything. However, you guys draw whatever conclusions from this you wish. When we first sent our letter, I got an autoresponder saying that the chair of New Mexico was not going to be available for anything until August 2nd, which just happened to be right around the time they expected an acknowledgement letter from the Secretary of State. I know some party members in New Mexico felt that everyone was laying low until they got this letter that they could wave in members' faces to try to intimidate Shire members into being silent, because look, the Secretary of State accepted it, not a thing you can do now. And the fact that the letter was posted on there when that hasn't been done for any other prior constitution and bylaws that I've seen, and it's not a general practice of any state party to do that, was kind of like, look, see, we're legitimate now. And as we learned in the Idaho case, the Secretary of State, all the acknowledgement means is we got the document. It doesn't mean it's valid or anything like that, but unsophisticated people can see that and think, oh, well, the game's over. I really didn't appreciate that letter being posted on the website that way, because to me, it was apparent what the purpose of that could be, or at least the effect of it, even if that wasn't the intent, because I don't know anyone's intent. But you want to know something at this point, I have some additional information that it has legal implications. I will yield to Mr. Hagopian, but when Mr. Hagopian is done, I'm going to move to for us to go into executive session. And I would like to say that if any motions come out of the executive session, I believe they need to be voted on by the entire LNC. So there wouldn't be any motions coming out of it. We just adjourn. I have no intention of making any kind of motion.
Thank you, Karen.
Okay, go right ahead.
Sorry. Quick question on the Secretary of State reaction. Is there any possible negative reaction in terms of our candidates on the ballot?
I saw that question. My understanding is there's not if we send them a letter, because I'm not asking, we're not saying that there's a dispute with any of the candidates. We're not associating it with ballot access. I looked into it a little bit, and I spent 20 minutes looking into it. That's how much time I spent, which is not an exhaustive search. But in that search, I didn't find anything that would hurt them, because that was a concern of mine.
Okay, my biggest concern here, other than all the stuff I said on the Idaho vote, is just risk versus reward. Going to the state versus taking action internally, which we've already done, which we can build off of with further action internally. Would be the route I'd prefer to go, but that's where I'll yield my.
Okay, prior to making the motion, just because I want to address something that was in chat, when you're speaking off the cuff, sometimes people can misread, or you can say things that are sloppy. I want to make it absolutely clear on the record that I am not saying that I know the motives of anybody, because I don't, and I did say that explicitly, but I see people are claiming otherwise in chat. So I do want to make it absolutely clear that I do not know the motives of anybody. What I can factually say is what some New Mexico members have told me they believe. I'm relating facts. I am not imputing judgment. I can only go by what's actually on the record, and people's minds are not on the record. So I am absolutely not imputing motives. If anything I said could be construed that way, I apologize and retract, because I am not. I would like to now move to go into executive session to talk about legal issues, legal implications surrounding legal issues surrounding the issue with the Libertarian Party of New Mexico.
Got it. Okay, it's been moved
Second.
and now it's been seconded. Any discussion on going into executive session? Any objections going into executive session? Going once, going twice.
And to be clear, Madam Chair, with the entire LNC present, not just the executive committee.
Okay, good to know. Okay, it's been moved and seconded. There's no objection on going into executive session. So we are going to go into executive session. So be it.
Madam Chair, can we have a 5-minute break to give members time to depart and to answer the call of nature?
Let's do it. Let's take a 5-minute break. Thank you for asking. We'll be back at 7:54, 7:59 Pacific time.
Okay, I am back and I'm going to start to manually remove non-LNC members who might not be, perhaps they've left and aren't paying attention, but I'm giving everyone a chance as we are going into executive session. So non-LNC members do need to depart the meeting.
Madam Secretary, while you're doing that, I'm wondering if maybe we can, and maybe we started doing this after you were no longer in the role last term. We used to set up like a parallel room that we could like hop into so that we didn't have to kick folks out. That way, if by chance anybody was crazy enough to want to stick around until we got back into regular session, if we decided not to adjourn, they would be able to just we could just hop right back into this room and they'd still be here. I don't know how that works logistically.
I do.
Okay.
I can. I don't know if the chair is here, but since there's no motions that I think can be made, we're just going to come out of executive session and adjourn.
Fair enough.
You
Yeah,
know,
and do it however you feel comfortable.
Yeah.
I was just curious about, like, you know, I didn't know if that was like something that we had to have like a special little account. to
No,
do.
it's enabled. And I was looking, if people were watching my screen, I was like, oops, I should have stopped screen sharing because I was Googling how to do a breakout room just in case. But and Wayne's left this room and didn't leave the meeting. I'm throwing him out. This is going to be fun. Bye, Wayne. Yeah. I don't, it says, do you want to report annoying user? No, he's not annoying. Don't report. He just left. And I'm going to shut that door before we get started. Yeah, the reason I thought that was a great idea last term, the breakout rooms, but that's because you guys intended upon coming back and possibly making motions. So now I'm gonna, since we're not gonna do that, it's a little bit of trouble. I know how to do it, but
No, whatever's easiest. I was just
okay.
curious.
All right, I am just, oh, I don't want to report. That'd have been
Is it
funny
gonna
if I
ask you that for
reported
every
Wayne
single
though.
person?
Okay,
Yeah.
are we down to just executive committee yet?
Well,
Not
you mean
quite.
LNC?
Oh, yes, I mean LNC.
Yeah, I'm removing the people I think that maybe walked away from their computer, because that's what Wayne did and he was still in here.
We've got, okay, yeah, you got it.
Okay, let me just go shut the door. So he's not here to shut it because, you know, when you have two people in the house that are both LP people, you got to keep it secret. So hold on.
And shut the door.
God, I should have put my contacts in for this. I can't see anything.
I threw his booty out. I'm like, Wayne, get out of the room.
If I could also ask if we stop the live stream.
Yeah, I'm going to, once the chair declares us going into out of break and going into executive session, I'm going to.
We're out of break and
Okay.
we're in executive session.
Okay, 1 second. Let me stop live stream. And it is 9 o'clock Mountain Time, so 11 Eastern.